Welcome to Community Legal Education Association's Legal Information for Tenants in Manitoba video series. This video is about how tenants can get out of a lease. This video was produced by Community Legal Education Association Manitoba, or CLEA, with funding provided by Justice Canada. CLEA is located in Winnipeg, Manitoba on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and the traditional homeland of the Métis people. Our water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and continues to be done. Therefore, we dedicate ourselves to moving forward in the spirit of reconciliation. This video contains information about Manitoba laws and is only intended for Manitoba residents. This video contains general legal information only and not specific legal advice. For legal advice about your specific situation, speak to a lawyer. Most tenants' lease agreements run year to year. This is called a fixed-term tenancy. If you do not renew your agreement within the amount of time specified in the agreement, it will end automatically on the date indicated. Other lease agreements are periodic. This means they run week to week or month to month and renew automatically. A tenant on a periodic tenancy agreement can end their tenancy by providing at least one payment period's notice to the landlord. Most people who sign tenancy agreements intend to stay for the length of the lease, but sometimes things happen that make it necessary to end the lease earlier than expected. You are not allowed to end your tenancy agreement early unless you have a valid legal reason for doing so. If you end your tenancy agreement early without a valid reason or without following the right requirements, you may have to continue paying rent for the remainder of your tenancy agreement. Even if you have a valid reason to end the tenancy early, you usually must give your landlord notice. Different situations require different periods of notice. You may need to provide proof that your situation falls into a specific category. You can call or email the residential tenancies branch to confirm the length of notice and whether any additional information is required for your specific situation. The residential tenancies branch is a government body that provides information to both tenants and landlords about their rights and obligations. The residential tenancies branch also investigates matters between tenants and landlords. A tenant ending their tenancy agreement early should use the standard form, Notice of Termination by Tenant. This form asks the tenant to fill in details including what date the tenancy will end. You may only end a fixed-term tenancy agreement before the end date of the agreement for specific reasons. These include household violence. A tenant may end their tenancy agreement early if they have immediate safety concerns about household violence, domestic violence, sexual violence, or stalking, and feel that they or their children are at risk. Household violence includes physical abuse of the tenant, attempts to physically abuse the tenant, psychological or emotional abuse of the tenant, including intimidation, harassment, coercion, or threats. This could include harm or threats to other persons, pets, or property. It could also include exposing a child or youth under 18 to direct or indirect violence against the tenant. Household violence could also include unreasonably restricting or preventing the financial or personal independence of the tenant. To end the tenancy for this reason, the tenant must usually give the landlord notice of at least one rental payment period, unless there is immediate danger. The tenant must also give the landlord a signed certificate provided by Manitoba Justice Victim Services confirming there are grounds to terminate the tenancy. In this situation, the entire tenancy agreement will be ended, even if there are other people named on the lease. You do not have to tell the other tenants that you have ended the lease unless you want to and feel comfortable doing so. The landlord must notify the other tenants of the termination. The other tenants may sign a new tenancy agreement if they want to. In the case of a termination due to household violence, domestic violence, sexual violence, or stalking, the landlord must keep the information they received confidential, and the landlord cannot ask you for more information about the situation. The landlord also cannot give you a bad reference because of it. All of your rights as a tenant and the usual procedures about security deposits still apply. Call the Domestic Violence Information Crisis Line at 1-877-977-0007 to discuss your options and get information about services in your area. The line is available 24 hours a day, 7 days a week, and all calls are confidential. Uninhabitable premises. In the case of uninhabitable premises, a tenant may end their tenancy with 5 days' notice if their health or safety is at risk, or immediately if the rental unit is in such bad condition that it is impossible for them to continue to live in it. The tenant should contact the appropriate inspection agency so that if there is a dispute later over whether the tenant had the right to give a short notice, the inspector can give information about the condition of the unit. Rehabilitation schemes. A rehabilitation scheme is when a landlord wants to do major improvements or renovations to the building and the rental units. The form landlords must use to tell tenants they are applying for a rehabilitation scheme is called a Notice to Tenant Rehabilitation Scheme for all or part of a residential complex. If you received this form and you want to move out, you can give your landlord notice of 2 rental payment periods at any time from the date you receive notice that the landlord has applied or intends to apply to 14 days after you receive either the first or final order from the branch or the Residential Tenancies Commission on the landlord's application. Health problems. If a tenant's income is reduced because of deteriorating health and they can no longer afford to pay their rent, they can terminate their tenancy by giving their landlord notice of at least 1 rental payment period. They must also provide a doctor's certificate as evidence. This process also applies to the roommates of a person who can no longer afford the rent because of a health condition. Military relocation. Canadian Forces members and their spouses may end a tenancy agreement early if they are posted to a location that is at least 50 kilometers from the rental unit. If they knew about the posting 3 months or more in advance, they must give 3 months' notice. Otherwise, they must give at least 1 month's notice. The tenant must also give the landlord a certificate from an official with the Canadian Forces confirming the posting. Accessibility reasons. A tenant may end a tenancy if, because of an ongoing decline or a change in their health, the rental unit is no longer accessible. For example, if the rental unit is 2 stories and the tenant can no longer climb stairs because of a health condition. The tenant must give the landlord a notice of at least 1 rental payment period. The tenant must also give the landlord a certificate from a doctor confirming that because of their health, the rental unit is no longer accessible. Tenant or co-tenant accepted into a personal care home or unable to live independently. A tenant may end a tenancy if they or another occupant of the unit have been accepted into a personal care home. The tenant must give the landlord notice of at least 1 rental payment period. A tenant may also end a tenancy if they or another occupant of the unit are no longer able to live independently. In this situation, the tenant must give the landlord notice of at least 1 rental payment period and a certificate from a doctor confirming that they can no longer live independently. Death of a tenant. If a tenant dies, the tenant's estate can end a tenancy with notice of at least 1 rental payment period. If one tenant dies and the remaining tenant or tenants can't afford the rent, they can also end the tenancy with notice of 1 rental payment period. An above guideline rent increase is also a reason why tenancies can legally be ended early. For details, see the video on above guideline rent increases. Tenants can also end their tenancy by assigning or subletting their unit. These 2 situations are often both referred to as subletting, but there are important differences between the 2. An assignment is when the tenant moves out of the unit permanently and a new tenant takes over their lease for the remainder of the term. In an assignment, the tenant's legal obligation to the landlord ends. Subletting is when a tenant moves out and a new tenant moves in for a period of time, but then the original tenant returns to the unit. In a sublet, the original tenant who signed the tenancy agreement can still be held liable for damages to the unit, unpaid rent, and other obligations related to the tenancy. A tenancy agreement may only be assigned or sublet with the landlord's prior written consent. It is a good idea to talk to your landlord before making these arrangements because they may have a waiting list of people who want to rent your unit. The landlord may charge a maximum of $75 for an assignment or sublet. For more information, visit the Community Legal Education Association's website at www.communitylegal.mb.ca.